Waukesha teen Nikita Casap was in court this past week for a second time, this time discussing the unaliving of his mother and his stepfather. Before he was in court, it was in regards to the theft of their vehicle. Now, for those of you that are not familiar with the case, we're going to watch this quick summary and then we'll watch the hearing that occurred this past week.
A teen boy is charged with shooting and killing his parents, living with their bodies for a week and a half.
Donald and Tatiana Mayer were found dead in their home on February 28th. Their bodies were severely decomposed. Prosecutors say Tatiana's son, 17-year-old Nikita Casap, shot and killed his mother and stepfather more than 2 weeks earlier.
Prosecutors say Donald and Tatiana Mayer had been dead for days, but their son, Nikita, was still there. Court filings say footage from a surveillance camera showed it trained on Donald Mayer's body, covered by blankets and pillows. Nikita entering the room to keep candles lit. At one point, Nikita grabbed the camera and turned it around and heard him say, "So you can see him there. I can literally see the rotten body." Court filings say investigators believe Nikita Casap killed his parents sometime on February 11th, but he didn't leave Waukesha until February 23rd. Traveling through Illinois, Iowa, Nebraska, Wyoming, and Colorado before getting arrested in rural northwestern Kansas in his parents' SUV. Filings say investigators found telegram messages in the days and weeks before the homicides between Casap and a Russian speaker, with Casap asking, "While in Ukraine, I'll be able to live a normal life, even when it's found out I did it." A Waukesha West classmate told investigators Casap told her he was planning to kill his parents and had been in contact with a man from Russia.
Ms. Blankenheim, I'm reluctant to start unless you give me a thumbs up, letting me know that everybody's here. I know that's not normal, but I keep having more and more with the correct identification file in, and I'm bringing them in immediately. Are you expecting more than two? Okay, thank you very much. Court's going to call 25 CF 435 as well as 25 CF 598, both of which are captioned State of Wisconsin versus Nikita Casap. Appearances, please.
Good afternoon, Commissioner Brooke Schultz for the state.
Nikita Casap appears in person and in custody with attorneys Maura McMahon and Nicole Ostrowski. Good afternoon.
Good afternoon to everyone. So it's my understanding that the 435 matter is long past. Oh, maybe not. I've got an amended complaint that was filed. Was there an initial appearance on the 435 matter already?
There was.
Oh, okay, I see it. March 12th.
Correct. And then we were scheduled for prelim March 24th. However, we filed a de novo motion that was supposed to be addressed tomorrow in terms of a status in front of Judge Ramirez at 1 o'clock. However, Attorney Basie had indicated to myself and Attorney McMahon that she would be moving to dismiss the 435 matter, noting that the charges on that were now in the new
598.
598. Thank you.
I'll note that this, so let's just start with that. The 598 matter is a 9-count criminal complaint that's scheduled to be in front of Honorable Ralph Ramirez, Branch 3. Allegation dates, there's ranges from February 11th or a range around February 11th and a range in and around February 23rd and in and around February 28th. I'll note that the first count is first-degree intentional homicide. This is a Class A felony, and if convicted, he shall be sentenced to imprisonment for life. Count 2 is a second count of first-degree intentional homicide with the exact same maximum punishment. Count 3 is hiding a corpse. This is a Class F felony, carries with it a maximum punishment of $25,000 or imprisonment of not more than 12 years, 6 months, or both. Count 4 is exactly the same thing as count 3. Count 5 is theft of movable property. This is a Class G felony, carries with it a maximum punishment of $25,000 or imprisonment of not more than 10 years or both because of the amount that's being alleged. Count 6 is theft of movable property, special facts. This is a Class H felony, carries with it a maximum punishment of $10,000 or imprisonment of not more than 6 years or both. Count 7 is operating a motor vehicle without the owner's consent. This too is a Class H felony with the same maximum punishments as count 6. Count 8 is identity theft. Again, another Class H felony, same maximum punishments as 6 and 7. Count 9 is identity theft. Again, another Class H felony, and I'm not going to repeat myself again. It's the same. You do acknowledge receipt of that complaint?
Yes, and I'd waive any additional reading.
Thank you very much. As it relates to the mailing address, where do you want his mail sent?
The address on the complaint is where Mr. Casap was residing. However, given the bail amount that he's on the 435 matter, his mailing address would be the jail.
Okay. Do you have a phone number that you'd like to provide?
The court has an accurate one. I don't remember it off the top of my head. I apologize.
We do have a phone number. It ends in, I'll just say 323. That sound appropriate?
Yes.
Okay. Given that you've acknowledged receipt, you waived the formal reading, I will tell you I've had the opportunity of reviewing the probable cause section of the complaint. He's entitled to a preliminary hearing before a finding of probable cause has been made, as all of these are felonies, but I would indicate based upon my brief read here today, do you have a motion? Because I'll note that I believe that the complaint is sufficient for today's purposes.
I don't have a motion other than noting, obviously, count 6 and count 7 are duplicitous for the 435 matter and the 598 matter. If the state is going to make a motion to dismiss the 435 matter today, then that would negate that motion, but I would make that record.
Okay. To the state.
Thank you. The state is asking for $5 million cash bail here, as previously indicated by defense and the commissioner. We are moving to dismiss 25 CF 435. We've now added new charges after further investigation into victim A and victim B's death and consolidated those previous charges with the new charges in 25 CF 598. In addition to the conditions previously requested at his last initial appearance, the state is also asking for no contact with witness A, as the defendant did threaten to kill witness A if she told anyone what he was telling her after he had given her information that he was speaking with someone from Russia. The state does believe he's an extreme flight risk here. He was found in Kansas with victim A and victim B's property. He's been speaking with someone in Russian about moving to Ukraine after committing these crimes. So the state is concerned that he's a flight risk if he is ever released. Thank you.
So I was not the court official on the 435 matter. So you indicated that you're asking the same conditions that were requested in that matter. I can tell you what was ordered, but I don't know what was requested.
I can relay those to the court.
Okay.
With conditions that the defendant be ordered not to leave the state of Wisconsin and surrender his passport, and not to use or possess any dangerous weapons. Based on the information that I previously provided, that we do believe he's a flight risk. He has no living family now in the state of Wisconsin. He was also found with a high amount of cash in his person when he was found in Kansas. So based on all of that information, that is what we were requesting.
Is there anybody here who would have the constitutional right to address this court and is wishing to do so? My record should reflect that my gallery is silent at this time. Attorney Ostrowski.
Thank you. We're asking the court to essentially maintain the same bail that Mr. Casap has been on. That was on the 435 matter, which is $250,000 cash. The reason that I think that's appropriate is obviously it's not an amount that can be attainable by Mr. Casap or anyone else who potentially could post that for him. He's been in on that cash for a significant period of time already at this juncture. In addition to that, noting obviously the serious nature of the allegations in the new criminal complaint, I would note that looking at the PSA tool, it takes into account the fact that Mr. Casap has absolutely no history, his young age, and things of that nature. And that says that the presumptive pretrial release level would be a level 1. I think 5 million cash is abundantly high and not something that the court needs to order at this juncture. So we would be asking for 250,000 cash. I have no objection to the conditions asked by the state. However, I would note that on the 25 CF 435 matter, Mr. Casap did fill out the passport slip, and it's my understanding that the state is in possession of that passport. And I think it might even be mentioned in the complaint that it was seized with the vehicle.
So you're going to return all of your future court appearances. You're going to have no further conduct that rises to the level of probable cause anywhere within the United States or its territories. You're going to have no contact with any remaining family members of victim A or B within the United States. You are not to share any of the information found within the victim identification key with anyone other than to an attorney looking to represent you in this matter. You are not to use or possess any dangerous weapons, including a knife, machete, pepper spray, taser, firearm, anything designed to maim, kill, or incapacitate another individual. You are to have no contact whatsoever with witness A. You're not to share any information found within the witness identification key with anyone other than to an attorney looking to represent you in this matter. In fact, if he is released, he can only be released during duty hours to WCS for the installation of a GPS monitoring device. I will set a 2-mile exclusion zone around the home, work, and/or school of witness A. I will inform Mr. Casap that if he comes within that exclusion zone, I will immediately issue a warrant for his arrest. If I get provided with that information, I will find that a situation so exigent that a warrant is necessary in order to ensure the safety of the community and witness A. I'll order that he not leave the state of Wisconsin. If he has a passport or any traveling documents, my understanding, he's already surrendered those and you've already provided the social security number, so I'm satisfied with that. Don't believe that there's anything that I have missed at this time. Very briefly, anything that I've missed, Attorney Schultz?
No.
Oh, thank you. I will order that if a sample of his DNA has not been provided, that a sample be provided pursuant to statute, as this is the type of matter that requires the mandatory collection of DNA. He can petition to have that be expunged at a later date in front of the trial court. And if they order that to be the case and agree that that's appropriate. Finally, lastly, to comply with any of the conditions of your bond may result in the state of Wisconsin issuing bail jumping charges against you. I've been sitting here struggling. This is a violent offense. So the legislature has made really clear what the court can consider as it relates to a violent offense, and that's the totality of the circumstances. I'm not limited to some of the same considerations, but unlike whatever was going on in the last court appearance, I now have charged and alleged 2 first-degree intentional homicide, the highest counts that we have, quite frankly, in our country is what's been alleged here. And not only can the court think about the totality of the circumstances, I routinely, it's not the first intentional homicide bail argument that I've heard, and I just don't understand. And maybe somebody can make me understand. And why aren't they utilizing the section found at 969.035? That's literally what it's made for. We're not even, I don't have to have the whole discussion as to whether or not 5 million is an appropriate amount for a child of 17, 18 years old, or if it's $250 or $10,000 or $100. He's alleged to have been charged. The district attorney's office can bring forward, something alleging underneath 969.035 sub 3. You can say he's not eligible for release. Provide the information. We can go through it, because when I go through this information, I look at this complaint. The subsequent investigation that whatever occurred after the first initial appearance seems to be extremely thorough. It seems to have additional information provided by a witness. It seems to have evidence that's been provided in this complaint of, they're indicating they've got video evidence, they've got communication, they've got transactions, they've got a litany of things. And I just don't understand, because it's not like if you don't get what you request in terms of the pretrial detention that you still don't get to argue bond, right? So I just don't understand. And maybe I'm taking my little 2 seconds to stand on my soapbox to try to figure out what's the amount. Is it 5 million? Is it 10 million? Is it 250? Is it 50? The reality, though, is this allegation, this young man, you would think would not necessarily have access to the sheer volume of funds that is being alleged inside of this complaint, besides the property that was there, the virtual currency that is being alleged, as well as what's alleged is he's connection with somebody. So his access to funds, I have no idea what they are. I don't know if he has access to 10,000 or 250,000 or 2 million. So the reality is I'm going to grant what the state's requesting, but in terms of a high cash bail, but it's not going to be 5 million. I don't even know how I'm going to attribute that. But I am going to give him a $1 million bail. I believe that that's appropriate, given the seriousness of the crimes, the totality of the circumstances, quite frankly, the strength of the state's evidence. And again, I urge the state, somebody use it. Somebody somewhere in the state of Wisconsin use the tool that's been given to you, please. He's entitled to a preliminary hearing within 10 days. How would you like me to calendar this?
We would like that within time limits, please.
I'll get you the date.
April 9th, 8:15, 9:15, or 10:15?
Can we do 9:15, please?
April 9th at 9:15, and that'll be right back here.
Thank you.
Thank you. Okay, so there you have it. I doubt he'll be able to get out on bail, but April the 9th was the date that they've scheduled here to come back and revisit this. So again, Leslie Basie from Waukesha, who is now the DA of Waukesha, is assisting on this case. So it'll be good to see her in court. I imagine we'll be able to see it once it does go to trial. So I wanted to stay on top of what's going on with it, each piece by piece as it comes. So stay tuned, everyone. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.